And good evening, everyone. Barry McGuire here for Barry McGuire's Creative Real Estate Education Series. It's live at 5 on Thursday, February the 11th. Today we're doing a field trip. I'm at Field Law, as you know, and every once in a while we do field trips. Interesting journeys into various aspects of the law that affect you as investors. And today it's all about condominiums. Condominiums form a large part of the housing market. They're a large part of investors' products that they like to buy and rent and accumulate. And so today we're very fortunate to have with us Erin Berney, who's with me at Field Law. Erin is, and we're not supposed to say this as lawyers, but I'm going to say it. She's a condominium specialist. What she does is her practice is mainly in the field of condominium law, and she's that rare lawyer, at least these days. Erin's a lawyer who goes to court. That means she's a litigator, and she stays in the office and works on documents and those kinds of things, and that means she is a solicitor. So she covers all areas of the law, and I think we're really fortunate to have her here to delve into lots of different areas. We had 3 topics lined up, and as we were just chatting, we've come up with 2 or 3 more. So there is no shortage of topics to talk about in the field of condominiums and condominium law, especially as it relates to investors. So with no further ado, we're gonna bring up Erin Berney, and we're gonna start this conversation going. Erin, welcome.
Hi, Barry. Thank you for having me.
Thanks for taking time out of, I know what's a very busy day for you. I know when I look at the list of files that show up, that we all get, to make sure that when you're starting with a new client, it's not some client I'm already fighting with, because we don't want to have conflicts. When that file list comes up, you're on there a lot. So I know and it's always Erin Berney regarding condominium law. So I know you're busy. So thanks for taking time to help us out.
Yeah, I'm happy to be here. Yeah.
All right. So there were a lot of topics. I know when you and I got together and we were deciding what we would talk about, we came up with a number of topics. We wanted to talk about bed bugs. Is a big topic in general conversation because bed bugs are everywhere. So bed bugs. Tenants, and did people know that a condominium corporation can evict your tenant? I mean, you might want to evict your tenant, but the condominium corp can do it too. So we'll have a chat about that and how they do it and why they do it. We also, maybe we'll talk a little bit about boards of directors. All condos have boards of directors, and that of course affects anyone's ownership of a condominium. And then you suggested, and I think it's a great idea, to talk about what about cold weather? What happens with cold weather, and if there's problems with pipes and freezing and repairs and all of that sort of thing. So as we said, we're not going to have any trouble with the topics and with things to discuss. So let's get right into bed bugs. And I know people are going to be really interested in hearing some of your real life stories about particular situations. Names changed to protect the innocent, or the guilty for that matter, but stories are always good. So bed bugs. I own a condominium. Don and I own a condominium, and we got a notice from our property manager that they thought that our tenants were the cause of bed bugs maneuvering off to the next door townhouse unit. And what were we going to do about that? And by the way, if there was costs to be paid, they were going to send us a bill. So tell us about bed bugs and condominiums.
Okay, well, so it's more of an issue when you have an apartment style condominium or a condo that does have shared walls between the units. So townhouses maybe could also be affected by this. But bed bugs can travel between those areas, between cracks in the walls, between shared heating apparatuses. If you have hydronic heating where you have pipes that run along the wall on the exterior of the building, there's usually gaps there where the bed bugs like to travel. And because it's warm, that's usually a spot where they like to hide and nest and things like that. So in general, as a unit owner, you're responsible for what happens within the four corners of your unit. You are responsible for any maintenance items, for any repairs and replacements. If you damage your floor, Condo Corporation doesn't pay for that, you do. But when there is a situation that affects multiple units, like a bed bug infestation, then the Condo Corporation does have a duty to get involved because the common property is being affected, as is the rights of other unit owners to have carefree use and enjoyment of their property. Bed bugs have actually been called by the courts to be a dangerous condition that needs to be remedied. Yep, there was a case out of Ontario that called it that, and a similar one in BC that upheld the right of a condo corporation to go into a unit to deal with a bed bug situation where the owner was refusing to address it. So, I mean, it reflects the underlying obligations of the corporation to care for, maintain, repair, and replace the common property, and to uphold the bylaws. Most often, there's a condition in the bylaws that provide that an owner shall not permit a condition to exist in his or her unit that would be considered a nuisance or a hazard, or be unsanitary, or that would interfere with or unreasonably interfere with the rights of other unit owners or other occupants to use their units. So that's what gives the corporation some leverage in these situations. It's also, I think, when you're dealing with a bed bug situation, it's also more important for the corporation to go in and tackle it, because you don't want to leave it to individual owners to either to mitigate or not as they see fit, or use different tools and strategies that might not be as effective as others. So then you have recurrence of the problem over and over and over again. And individual owners incurring costs, whereas if the corporation were to go in, perform the necessary inspections, identify all of the affected units at once, and treat them all at the same time with appropriate methods, whether that's chemical sprays or heat treatments, which are becoming more popular, and safer for some people with allergies or conditions where the chemicals might not be appropriate. The heat treatments can work just as well, but they have to be done multiple times, usually over a couple of weeks. So there's a lot of arranging for access that needs to be done, a lot of coordinating with tenants or with unit owners to gain access, and then ultimately a big bill at the end that the corporation has to pay for. Now, where the corporation can track down a source unit with reasonable certainty, or beyond a balance of probabilities at least, where there's some evidence that the unit owner or occupant has been allowing the condition to exist or was the cause of the condition in the first place, then it is possible for the corporation to try and recoup its costs from that particular unit owner or occupant, as the case may be. So that is possible. Barry, you look like you've there question.
That is running around in my mind because when I got notice from my condo corp that there were bed bugs, and they said, and because of this, and this, we're pretty sure the infestation is coming from your unit. So yeah, it's not ways of doing it.
Yeah, I mean, it is possible, but it's not a slam dunk. Obviously, the corporation still has to meet its burden of proof, and the standard, of course, is in most civil cases like this would be a balance of probabilities. So that's not like a criminal standard, not beyond a reasonable doubt. It doesn't have to come that high or with that much certainty. It's just, is it more likely than not that the bed bug situation originated in this unit and then spread from there? And it's actually difficult to prove with bed bugs because they can be brought in any number of different ways. They can be on a piece of furniture that was moved through the common property hallway, for example, and then spread to units that way. They can be transferred from clothing. if people have been traveling, they can come back in luggage, in suitcases and things like that, and then spread from there. So it is difficult to try and pinpoint them. It's not an easy burden to meet, or a standard of proof to meet. But it is possible for the corporation to do that. And if the bylaws of the particular corporation allow the corporation to charge back those costs, then you may want to get a lawyer involved if you've received a letter like that, because a chargeback is it can be treated like an unpaid condo fee. They can basically say, okay, we think we have enough proof. We're charging it back. We can register a caveat in respect of that amount, that unpaid invoice for bed bug remediation. And once we've done that, we can alert your mortgagee if you have one. And the mortgage company, the banking institution, can pay that amount on your behalf and add it to your outstanding mortgage balance. If the bylaws don't treat chargebacks in that fashion, then the corporation would be required to actually bring a lawsuit, obtain a judgment, and file a writ against your unit before it would be capable of actually enforcing or collecting that unpaid amount.
But most bylaws do have that, don't they? Most of them.
A lot of them do, yeah.
So then, as you talk about this, I'm thinking of COVID, and there are a lot of people who think, rightly or wrongly, and I'm not passing judgment on them, they think that the government is violating their rights by imposing COVID conditions, and so there's a lot of upset people about what government says we have to do. And so I'm thinking, if you are a condo owner and you've got notice from your condominium corporation that they think there are bed bugs in your unit, and you think that's a pile of what, and you're going, you're not going to trample on my rights. You can't do that. And so there's a bit of back and forth with the condo corp. And I'm guessing that if this condo owner stands on their hind legs and refuses to allow access, and I'm thinking to some of those cases you talked about at the beginning, the condo corp can gain access. I'm pretty sure they can get an order to gain access. And as they work their way through all that, the caveat gets filed against the title, and there would be huge costs for that condo owner to pay, which they would only not have to pay by fighting a lawsuit, which is tough to do. I mean, is that really what will happen if somebody decides?
I have seen that happen firsthand. The costs ended up being in the $34,000 range, I think, before all was said and done. That's just the legal costs. The underlying invoices at issue were roughly $6,000. Yeah. So that's what it took ultimately. But the corporation in that case, they did get their order. They were granted not only an order for access, but the owner had to comply with any reasonable mitigation plan if bed bugs were discovered in particular unit, which they were. And an invoice and a report from the pest remediation company was sufficient in the court's mind to justify the chargeback, to determine that this was in fact the source unit. The bed bug or the pest remediation company being the experts, they assess the conditions in the unit when they get in there, describe it and say, the conditions were such, this person was a hoarder, for example. So it was impossible to keep the unit clean and free of vermin. It was obviously the source unit compared to the other units that they had inspected in the surrounding vicinity. So all the way around, both sides, plus across the hall, and then below and above. And in some cases, all those units need to be involved in any sort of remediation program or plan, because they could all potentially be affected just because of that one unit.
So there's the balance of probabilities for that particular scenario. Yeah. The hoarder unit, it's no trouble convincing a court that on a balance of probabilities, it's most likely coming from the hoarder unit.
Yes.
So now on a practical basis, when I get calls from people saying, okay, gee, so I didn't pay my condo fee for 1 month, and then I got in touch with them and I said I was going to pay, but they didn't respond, and then the next thing I know, and then I paid, and then they send me a notice saying they're going to put a caveat on, and that's not fair because I caught up, and right now I don't owe them anything, but they say they sent it to their lawyer and there's a caveat, and gall darn it, they're taking advantage of me, and I've had so many of those turn into the giant bill that the owners have to pay in the end anyway. So for $300 or $400 or $500 worth of condo fees, they end up paying a $3,000 condo lawyer bill. That it's just what I want people to get here is the message that, practically speaking, it's difficult to fight a condo corp who thinks they're in the right, who have lawyers on their side, who have bylaws on their side. It's really hard for an owner to resist and fight that without attracting a whole bunch of legal liability and dollar liability. Is that not really the way it is?
It is to a certain extent. A corporation needs to approach every situation reasonably and consider what's in the best interests of the corporation as a whole before taking any drastic action. The courts, particularly in Alberta, like to endorse what they call the incremental approach when you're dealing with unit owners. And that should apply whether it's a matter of arrears and condo fees, or whether it's a bylaw violation or a bed bug situation. But unless it's an emergency situation, incremental is the way to go. You have to consider, well, is it worth spending $5,000 or $6,000 on legal fees to go after a $500 bill? When the guy is only behind 1 month or something, or the invoice is that small. So you need to take that into account. And as board members, those are your duties, to act in the best interest of the corporation at all times when you're faced with situations like this and you have to make those decisions. But on the flip side of that, when you live in a condominium, you agree to abide by a set of bylaws. You're deemed to have knowledge of those bylaws and to have agreed with them. They're considered almost like a contract under seal that bind all of the owners as well as anyone who's in possession of the condo, of the unit. So to a certain extent, you give up certain rights to property and to use your property in a way that you want, that you would enjoy otherwise if you had a single family detached home. And that's the nature of condominium living. You give up some of those rights in exchange for benefits along other lines. For one, it's more affordable housing. You pay some common fees to take care of things like landscaping and snow removal, so you don't have to worry about doing that. You share the costs of large capital replacements, large projects like that, with other unit owners. So to a certain extent, those costs are defrayed over time and mitigated. So you don't get hit with a single large bill when you have to replace the roof or replace the windows or something like that. So that's the trade-off. You give up certain rights in exchange for other benefits. You agree to live under that system of rules, that particular set of bylaws in exchange. So
okay, well, before we leave the topic of bed bugs, I think what I'm taking away from this, the very practical approach for investors who own condominiums, is if something shows up from the condo corp about bed bugs and they want to do something in your unit, I think you're way better off on a practical basis, even if you're pretty sure it's not your tenants or your unit that's causing the problem. I think you're almost always going to be better off going, okay,
yeah,
the question of bed bugs is a bigger question than whether they can really prove I did it. My tenants might leave if this isn't solved. I might not be able to rent the unit. I'm going to lose way more in monthly rent and in re-rental costs than I am in swallowing my need to have it proved exactly than I am in working with the condo corp to get rid of the problem as quick as we can for as little money as we can and figure out what we can do to not have that happen again. I think that's a a much better practical approach for any folks who are watching this that own condominium units.
I would definitely agree with you there, Barry. It's much better to approach, you know, any letter like that you might get from your condo board. Respond as soon as you can. Be cooperative to a reasonable extent, that is. Try to encourage any tenant that you have in there to be cooperative and to establish a reasonable time for the inspection to occur, to determine, number one, are there any bed bugs in the unit itself? I mean, if they can't find bed bugs in your unit, like let's say they bring in a canine sniffer dog or something, you know, to that effect, they're used quite a lot these days now too, to determine the presence or absence of bed bugs. That may determine, okay, once and for all, there's no bed bugs here, so your unit cannot possibly be the source. On the flip side, though, if you are an owner who is renting their unit and your tenant leaves because of a bed bug situation that the corporation is refusing to deal with, and instead putting it on the individual unit owners to deal with themselves, then you could potentially have a cause of action against the corporation to compel it to do its duties with regard to the maintenance of the common property, and with respect to enforcing the bylaws, being not allowing a unit to cause a nuisance or be a hazard or unreasonably interfere with the use and enjoyment by other occupants. So, yeah, and in that case where you have a tenant that has left, you could potentially have damages for lost rent as well.
All right. Wow, bed bugs. Who knew? Let's move on to this scenario. So you are a condominium owner. You rent out your unit. As far as you're concerned, you've rented to a tenant that you vetted carefully. They seem great. They're never any problem for you. And then you get a notice from the condominium corporation that they're evicting your tenant. So are they allowed to do that? And for what reasons could they evict your tenant, for God's sake? It's not their tenant, it's your tenant.
So yeah, it's actually a little known fact that a condo corporation does have the power to evict a tenant of a condo unit. This power overrides anything in the tenancy agreement in the lease, and it overrides the provisions in the Residential Tenancies Act for that matter as well. Yes, yeah, the provisions in the Condominium Property Act for eviction, they supersede the RTA in that regard. So there's a couple of circumstances where a condominium corporation may consider evicting a tenant and where they would have the authority to do so. Number one is where a tenant causes damage to the common property. That would be one ground for evicting. Although, again, we backtrack to what the courts have previously said, that in dealings with condominium corporations, and I think that extends to dealings with tenants of owners, the incremental approach is to be adopted here. So the court is not likely to grant an eviction for a scuff mark on a wall. However, if your tenant were to drive a truck through the front door or have guests over that this actually happened, defecate in the hallway, then that's another story. And that kind of damage might not only justify an eviction, but it would also potentially justify an eviction on an urgent basis with less than 3 days notice, actually. Yeah, in the normal course, the condominium corporation's eviction process is still rather fast, regardless of any terms in the lease or the duration of the lease. If they send a notice of eviction, it takes effect at the end of the month next following the month in which it was served. So if I were to serve a notice of eviction on behalf of a corporation today, it would take effect at the end of March 31st. The tenant would have to be gone by then. If the tenant refuses to leave, at that point, the corporation could proceed to bring a court application to get an order to have the tenant removed, or ordered to give up possession, rather. So yeah, I was describing the circumstance with the damage to the common property. That's one ground. Another one is where the tenant is breaching the bylaws or violating the bylaws. I'm not talking about any rules that the board might have passed that supplement the bylaws, but the bylaws themselves. It has to be a bylaw violation. So, for example, if your bylaws say there is no smoking in the common property, but your tenant is smoking in the hallways and the elevators, that could be grounds for eviction, for sure. Just trying to think, if a noise bylaw would be, that's a common one. If your tenant is having loud parties, blasting music all hours of the day and night, and people are complaining to the board, then yes, that could also be grounds for eviction. But almost always, every condo almost always has a general noise bylaw, so that would be violated in a case like that. So, cases where an urgent eviction could be ordered are situations where you have to prove that there's an immediate threat, that there's a harassing or a threatening behavior that the tenant has been displaying. Almost always in those circumstances, usually there's police involvement. Often it's an assault or a severe case of vandalism or something to that effect. And it's, again, I caution with the incremental approach, depending on the seriousness of the situation, the level of threat, if it's immediate or not, that might move you back and forth between whether you can go for immediate eviction on 3 days notice, or whether you have to go with the less serious eviction on the month next following the month in which the notice is served. One thing to note, though, is that the eviction notice that you serve on the tenant has to also be provided to the unit owner. So at that time, what I usually counsel condominium corporations to do is give the unit owner an opportunity to take control of the situation and, if possible, bring an RTDRS application to terminate the tenancy that way. It dramatically reduces the amount of legal fees and court costs involved that, if your bylaws provide, could potentially be chargeable back to the unit owner or ordered back to the unit owner in the case of a court action. So the unit owner might ultimately be responsible for a huge legal bill if they just sit by and don't take any steps or any actions to deal with any issues by their tenants, and instead let the corporation proceed with a court-ordered eviction under the Condominium Property Act. So I've seen that work in a number of cases where, you know, you give the owner the opportunity, give them the heads up. Sometimes they don't even know what's going on. So you fill them in, you provide them with the background, the police files sometimes, you know, photos from the security surveillance cameras in the hallways that captured the vandalism or the damage or whatever the case may be. And you give them the opportunity to do it. Maybe give them a firm time frame within which, you know, get back to us, confirm that you're taking some steps, that you've issued your own eviction notice, or that you've initiated your own RTDRS application, and we'll sit back and we won't try to charge any costs back to you. We won't take further action. That's what I endorse as a first step, rather than immediately going into court and trying to get that order, because the costs escalate quickly.
So this is a couple of good points coming out of that. So I think that what people have to hear is that there is no mechanism like the RTDRS, as there is under the Residential Tenancies Act. There's no mechanism for an owner to make an application to the RTDRS, for instance, to deal with the condominium's order to them. I like it. I really think it's a great idea that you're coaching corporations to get in touch with the owner and say, listen, here are the facts. And I guess there could be a discussion over whether what the corporation is saying is actually happening. But for the purposes of this discussion, let's just say that I'm pretty sure corporations are going to be pretty careful about evicting tenants unless they believe they have very good reason to do that. So I'm going to assume for what we're talking about that there is reason. So really, if one of our folks gets that notice, that eviction notice from the board, and the board isn't one of those boards that says, now we really think that what you should do to save some time and money and costs is we think you should go to the RTDRS and deal with this. So if the board doesn't say that because they don't have the right coaching, I guess what we're telling the folks listening is you should get in touch with the board and you should volunteer to do that and you should jump on it and get that done. Is that how they would handle that?
Yeah, I mean, assuming that there's no dispute on the facts, on the allegations that are being made by the condo corporation, because I've seen the flip side, where I've been contacted by an owner who's received those notices, and he's convinced that no, my tenant's an angel, I've never had any issues, it's fine, and reality is usually somewhere in the middle, but sometimes things are also pretty black and white when the corporation's presenting you with security footage. That you can pinpoint, that's my tenant right there, throwing the rock through the front window or something like that, yeah. Whatever it might be. So, I mean, in that case, when it's pretty undisputable, yeah, that's the best advice I could provide for unit owners, that if the corporation's not already giving you this option, then that's something you should approach them with and suggest that, whoa, hold on, how about you just hold off, give me 2-3 weeks. Let me see if I can get an application date with RTDRS. And for now, I mean, their RTDRS was still hearing applications by phone, and they were prioritizing hearings that where the relief being sought was removal of a tenant and recovery of possession of the rented premises. So I mean, those applications are still being prioritized, and they're still, as far as I know, only $75. Whereas court applications, court fees, preparing an affidavit, preparing an application, doing the necessary research, communications with the client, all of that adds up pretty quickly. I'm usually quoting between $8,000 and $10,000 for that kind of application just to get started.
Okay, so sorry, I didn't quite hear that, Erin. It's how much if you have to bring it, folks? We're just going to hear this again. How much is it that the condominium corporation is going to have to pay their lawyer?
Probably between $8,000 to $10,000 at least.
Oh. All right. So we talked about bed bugs and how you could run up a big legal bill. I don't think we got into actual dollar figures there, but that is probably a fairly normal application where you have to do normal things and there's not a big fight going on.
Well, exactly.
If there's a fight going on, the bill is going like this.
Absolutely. If legal counsel gets involved on the other side and you're fighting about everything, there's questionings that are conducted. Applications keep getting adjourned to allow for questionings. The bill goes up and up and up. So.
Yeah, and for those folks listening, I mean, if you're a lawyer and your client is a condominium corporation and they want you to do the kinds of things that Erin is talking about, it's actually wonderful work for a lawyer. It's wonderful work because you have a nice big entity who has money and who will certainly pay you and who wants you to get out and do your job. And it's great. You don't have, it's not as, of course, it's always fee sensitive. You can't charge people the moon, but you can do your job and you can be properly paid and not really have to worry about whether or not your client's concerned that you're spending an extra $500. So other lawyers, they'll grasp onto these and they'll go hard. So folks, the $8,000 to $10,000 is the starting number. Now, just one moment here, Donna. What am I doing here then? All right. So we're going to answer Veldon Palm's question right now, right in the middle of things. Veldon, what an upsetter you are. I know Veldon, so I can say that. All right. Veldon says, with said condo corp eviction to your tenant, is the board able to unilaterally assess a fine and attribute it to the unit owner? Good question, Veldon. Erin. So
theoretically, it's possible. It really depends on what your bylaws say and if they actually permit levying of a fine. The legislation allows you to levy a fine, but it also says that your bylaws have to specify what fine amounts the corporation can actually impose. In the absence of a bylaw that has a specific dollar amount, the corporation can't levy a fine. That's number one. Number two, fines can only be levied for actual violations of bylaws, not for violating any rules or policies or guidelines or standards or anything like that. It has to be a bylaw. So the board would have to find a particular bylaw that it can allege the owner to have violated before it can levy a fine. There is one, however, in these circumstances that might apply. Often there is a bylaw that says that an owner is responsible for ensuring that he complies with all the bylaws and that all his occupants and tenants of his unit comply with the bylaws. So if your tenant is being evicted for violation of the bylaws, then obviously the owner has failed in its duty to ensure that its occupants comply with the bylaws. So that could be considered a bylaw violation, justifying the imposition of a fine. Yeah, but it is important to remember also, fines are not the same as condo fees or chargebacks or anything like that. Fines, before a corporation can legally pursue collection of a fine, it has to prove the underlying bylaw violation. So to do that, if the owner's not willing to pay willingly, the corporation would have to go to court. It would have to bring an action and obtain a judgment on that fine, proving that the bylaw exists, that the owner violated it, and that the fine was properly levied in accordance with the proper procedures and everything set out in the bylaws and in the Condo Property Act. Now there's some new regulations that actually say before a corporation can levy a fine, it has to give the person 3 days notice minimum before it can do so. So it'd have to send out a written notice saying to the person, look, you're violating this bylaw with this behavior. It has to stop immediately. You have 3 days. And if it continues, we're going to levy a fine of this amount. And this amount for every time it happens, or if it's the case of a kind of an ongoing, continuous type of offense, then they can do a set amount per week until it stops. So at some point, these fines build up, but the owner doesn't pay them. The only way that the corporation can collect them is by going to court. So that's the thing.
So just contrast that, Erin, with the situation where someone is not paying condo fees. Right. How is that different than the fine situation, especially under the new regulations?
Yeah, so fines and chargebacks and condo fees. Fines are on this side. Condo fees, special levies, and chargebacks are over here. They're a completely different animal. Condo fees, special levies, and chargebacks benefit from a statutory protection. They're actually given priority for the condo corporation to be able to collect them. They're charges that run with the land, the unit, not the occupant or the owner. So if they're unpaid, the corporation can in fact enforce foreclosure to extract its pound of flesh, so to speak. One of the biggest powers it has, though, is to notify the registered mortgagee if there is one. So if you have a mortgage through some bank, it can tell your bank that, hey, you're not paying your condo fees. The arrears are up to here now, and we've been charging interest on that. So pay up, or we're gonna initiate foreclosure proceedings. We're going to register a caveat against your unit. Most often in those situations, the mortgagee will look at that and say, we better pay this, or it will potentially eat into our security, the equity in the unit itself that we're interested in protecting. And we want to maintain the priority of our mortgage on the property. We don't want a caveat from a condo corporation on there that would take precedence over our prior registered mortgage. So that's the difference between condo fees and special levies and fines. Fines, you can never caveat for a fine. A mortgagee will never pay a fine on your behalf. It might pay your condo fees, it might pay your special levies and your chargebacks, but it'll never pay a fine.
All right, so that's important for investors because mortgages are harder and harder to get, and I can see a lender, a bank, after they get a note from the condo corp saying, by the way, there's $3,500 in condo fees owing, and we're going to foreclose. And they can foreclose just like a bank can foreclose. The condo corp can foreclose. It's the same thing. I can see a bank going, okay, fine, we're going to pay up those condo fees so our position is not impaired. Now let's just see, when is this mortgage coming up for renewal? Oh yeah, 6 months. Just put a little red flag next to it that when this thing comes up, we are not renewing this mortgage.
Yep.
And in these days of tougher to get mortgages, that would be a big blow to any condominium owner who had that note from the bank. Internally, they go, this person is not a good risk anymore. So
they might not go to that extreme, or they actually might go further and decide that they're going to foreclose now instead of the condo corporation, because failure to pay your condo fees is considered a violation of your mortgage terms. So there's that, but it can also take other steps. For example, it can remove prepayment privileges. It can, if you have a biweekly prepayment or repayment program in place, it can remove that and require you to pay monthly instead. So it can do a whole bunch of different things if you're in arrears for condo fees and the bank has to pay on your behalf.
Well, the takeaways coming from these two topics are as a condo owner, as an investor who rents out a unit, you're always way better to calmly listen to what's going on with the condo corp, explore the problem or the issue, to do your very best to settle it in a way that gets rid of the problem, not to stand up and fight typically. And you're going to be way farther ahead in terms of time and money and angst and stress than you are if you ignore and fight and decide you want to litigate everything. So I'm kind of getting that as a lesson that runs through both of those circumstances.
I think those are some pretty good takeaways from those examples for sure.
All right, well, let's move over to it's bloody cold outside. I'm very glad I have a block heater on my car, because I park it outside, and surge starts a lot better in the morning. But I was reading the other day, I thought that a block heater was a kind of a standard thing for cars to have here in Canada, but it isn't. You have to, it's an extra. It's an extra. So you never think about your block heater until it gets this cold. But what sort of things do our folks need to hear about that they need to watch for when it's 30 or 35 or 40 below?
So when the weather gets this cold, every year the cycle happens for me. I start getting calls from my clients saying, we need to get access to this unit. We've had a pipe burst. There's water dripping from the ceiling. It can turn into a nightmare pretty quickly. In normal years, people would go away for the winter, so sometimes there'd be vacant condo units in which the damage would occur. That was not the case this year or last year for that matter, because of COVID. But it is still happening. People inadvertently leave their windows open a crack. Tenants leave windows open. This happens quite a lot. As a matter of fact, I had a case recently involving tenants what we were trying to evict, working with the unit owner, but they had then broken back into the unit through the window. By backing a truck against the back of the building, climbing up, scaling that on the outside of the wall to access this second-story window to get into this condo unit. And they had left the window open and then the weather changed. So fortunately, the pipes didn't burst in that case, because we found out about their occupancy, squatting, more or less, before it got too late. So we were able to go in and fix things up and make sure that they were gone, and there was no issue. But this week I've gotten several calls alone from condo corporations and property managers that need advice and assistance trying to gain access to the unit because a tenant is refusing or the owner is refusing for whatever reason. Just a tip. 90% of the time when somebody is refusing access to the unit, it's usually because the cause of the water leak or whatever it is in that unit, and they're trying their hardest to clean it up before anybody sees that it was, that it was coming from their unit, that they left the bathtub running, for example. That actually happened last October, but another file of mine. But in this case, no, it's pipes bursting, mostly because of the cold temperatures. So there is a new law that just came into effect January 2020 that actually codifies the common law and specifically allows condo corporations to recover amounts for repairs up to their insurance deductibles for these types of losses. It also makes the unit owner absolutely liable for any damage when the cause of the insured loss originates within that owner's unit or within that owner's exclusive use area. Absolute liability, that's a big deal. That's not strict liability. Absolute liability is like when you get a speeding ticket. You can't really fight that unless you can prove that, that there was something wrong with the gun, that you weren't actually going that fast. Otherwise, you are absolutely liable. The only thing you can do is maybe try and negotiate on the amount, which, you can still do in this case. Depends on what the bylaws say and what the corporation might be entitled. But first things first, there's the duty to repair. The corporation needs to get in there sooner rather than later, because water damage, that can pose an emergency situation. If it's not remediated quickly and the right way, it will of course lead to mold, which will cause all sorts of other issues and damages and potentially even personal injury. So there's a reason that they need to get in there right away. And it's, as an owner or a tenant, it's in your best interest to make sure that you cooperate in allowing them to have that access. You want them to bring in the air movers. You want them to bring in the dehumidifiers. This is going to be necessary, and this is going to save a lot of money in the long run, probably. You want them to remove the damaged building material, the water-soaked carpeting or underlay, maybe even cutting out portions of the drywall, depending on how high the water goes up or how much was affected. In units that are below the unit where the leak occurred, sometimes the ceiling, parts of the ceiling need to come out. So all that material needs to be removed as quickly as possible so that there's no lasting health issues or anything like that for the people that are living there. So that's number one. The corporation has a duty to respond and to repair when there's an insured loss. It has a duty to repair all property that it is required to insure. In an apartment style building, that includes the individual units, not just the common property. So it has to repair the units back to the state that the state that they were in beforehand, for the most part, subject to certain conditions. For example, if the owners made improvements, the corporation might not be responsible for those, depending on the bylaws. Now, also, there's a concept called a standard insurable unit description that sets out standard fixtures and finishings that the corporation will repair and replace, that they are responsible for insuring. And beyond that, if the owner makes an improvement or an upgrade from that standard base, then the owner is responsible for all of those changes. So that's something, if you've upgraded your condo unit, you should make sure that you've got improvement insurance for improvements and betterments. If you've changed laminate flooring to hardwood flooring, for example, that would be considered an improvement made by the unit owner, and something that most likely the corporation's not going to have to cover. When in doubt, you have to check your bylaws to see what kind of insurance the corporation is required to have, whether it insures unit owner improvements and betterments or not. That'll be set out in the bylaws. One issue that I've seen come up lately is that with this new standard insurable unit description process that's just come out, corporations that actually have a bylaw requiring the insuring of improvements are then registering standard insurable unit descriptions, which conflict with its duty to cover all unit owner improvements and betterments under the bylaws. I think something that might pop up in the next few years. We might see some litigation over that to see which takes precedence. I wouldn't want to speculate as to which would be more operative, but I would think probably the bylaws. So if the bylaws say one thing and your standard insurable unit description says something else, it's most likely going to be the bylaws that would prevail in a situation like that. But so I've kind of digressed a little bit, but getting back to the what happens after there's a water loss and the corporations come in, they've removed all of the damaged material. Then it has to go about getting quotes for repairs and arranging access to make those repairs. Sometimes there's disputes with the unit owners over what's covered, and that's where we refer to the bylaws or the standard insurable unit description, as the case may be. And then in the end, there's a bill. So the bill depending on the amount, the corporation may choose to make an insurance claim, but more often than not, it's probably doesn't want to. Given what we've seen with insurance rates across the country recently, for condominium corporations, premiums have just been skyrocketing due to the number of claims and a number of other factors that are beyond our control. So whether it makes a claim or not, however, it can still recover those costs from the unit owner if the loss originated in that unit. So whether or not the owner did something negligent or the tenant did something negligent, like leaving a window open, which does happen, but whether or not that was the cause, if it originates in that unit, like a faulty zone valve, for example, the corporation can potentially recover those costs from you. So that's something to keep in mind. Another thing to check for on your insurance, in addition to having improvements and betterments, is having what's called deductible chargeback insurance or chargeback insurance. A lot of policies offer this as a kind of a standard. It's usually only maybe $20 extra a year, I think, for a condo unit policy. Depends on the insurer. But it can provide you with coverage for up to $50,000 potentially for those kinds of chargebacks, and it's something that every condo unit owner should have as a matter of course.
So yeah, a couple of things coming out of that. So the rules changed recently. You said January 2020, so that there's absolute liability on the owner. What was the standard before the change?
So it was a little unclear. For the most part, the courts were allowing such chargebacks up to the amount of the insurance deductible. And the reason why the insurance deductible was kind of the limiting factor is because there's some wording in the legislation that specifically says the corporation shall insure the units to the full replacement value, but that insurance is subject to any reasonable deductible agreed upon between the corporation and its insurer. For a number of years, reasonable deductible was kind of up in the air. There was a court case probably 15 years ago, maybe 12 years ago, something like that, that speculated that a $10,000 deductible was astronomical and out of this world. And now we know that $10,000 is actually not too bad. We've seen deductibles in the range of $50,000 and up. I've seen some of my clients having deductibles over $100,000. Others with annual premiums in the several $100,000 range. So it's a little out of control right now, and it's hopefully there will be some changes. The legislature's looking into it. The Insurance Institute of Canada is looking into it. Insurance Bureau is looking into it. Everybody's trying to figure out a solution. We don't quite know what's going to happen right now, though. So,
okay. So then on the insurance side of things, because of claims, insurance companies just don't jam up premium costs because they feel like it. That's a very analytical, data-driven business, and it's their claims experience that makes the premiums go higher. So I'm thinking to myself that for any of our watchers who are looking to buy a condominium unit, I would be delving a lot more into what the condominium corporation's claims experience has been over the last little while. Where are they at with their insurance? Have they, what have their premiums done? Have they been refused? Have they been refused insurance? Because I have heard of a number of corporations who have been refused insurance, and they end up paying absolutely astronomical premiums. And if your corporation is paying astronomical premiums or can't get insurance, that comes right back and smacks you as a condo owner in the fees that you have to pay. So that's another element of diligence that I don't think has been emphasized for folks looking to buy a condo, and it's now very important, I would think. Yeah,
definitely. I think you pointed that out, Barry. It's it's a purchaser's responsibility to review the condominium documents that they're provided. Included among those, you're going to get copies of minutes of the board meetings, a set of AGM minutes at least one set, maybe even more. And you can always ask for more as well. And you're entitled to receive it, and you can pay for additional copies of things that, if you want to see go further back. You'll also get the most recent annual financial statements and the most recent reserve fund report and things like that. But you can tell from looking at the most recent financial statement, what is the corporation paying for insurance every year? There's going to be a line item for insurance. There's going to, if it's high and the financials have been audited or at least reviewed, then there might even be notes in the financial statement that explain that there was, this is higher than the budgeted amount because there was a claim and we had to pay X amount for this or adjuster's fees or whatever it might be over and above the budgeted premiums that we were planning on paying, and that's it. Right. So, but a sound financial plan for a condo corporation is to budget not only for the premiums, but also potentially to have to pay the deductible. So you should be including some amounts for the potential to need to pay a deductible. Otherwise that's going to come at you in the form of a special levy on all the unit owners at an unexpected time with very, very little notice. And, I saw a comment earlier, a question about how much notice needs to be provided for a special levy. And the answer is there's no legislated amount or minimum notice. It just says as quickly as possible. I believe it might not be that exact wording, but it's something like that. It is in as short a time period as possible. The board has to notify the owners that it's levied a special assessment. So.
All right, so let's get on to some questions here, Erin. Wayne, we had a question up for a bit that we didn't answer. Can you go back to the last one about
insurance?
Tenants insurance? Let's talk about that. So how would a tenant's insurance policy mitigate these kinds of costs? We kind of talked around that, but let's have some more specifics here.
Okay, so in the end, the bottom line is that the corporation doesn't have to go through your tenant. If your tenant actually was negligent and left the window open and that caused the pipes to burst and damaged 2 floors of the condo building, including your unit, it does not have to go through the tenant anymore or at all. It can go directly to you and collect its whatever amount is necessary for the repairs, up to whatever their associated insurance deductible is, to a maximum of $50,000. That's the legislated maximum. So if your deductible is $25,000, the repairs only cost $12,000, you're capped at $12,000. If the deductible is $75,000 and the repairs were $54,000, you're stuck at $50,000 still. That's how that works. The owner, though, the owner's insurance policy, when they pay out on your deductible chargeback insurance claim, you've paid your deductible, your insurance company pays the corporation, your insurer can then go after the tenant. And that's how that works. It's not up to you. You've subrogated. Your insurer decides whether or not it's going to bother, and if it's worthwhile. And if your tenant has insurance, that makes it a little easier. It's just money changing hands rather cordially, in fact. But if your tenant doesn't have insurance, then your insurer might decide it's not worth going after them. Depends on the cost. You would be required to cooperate under the terms of your policy in any case that they might want to bring against your tenant. But you don't necessarily have to initiate that if you have the deductible chargeback insurance that covers you for the loss.
All right, so folks, the lesson there is we all say in our leases that tenants should maintain tenants insurance policies, and I'm willing to bet big money that we might be careful about it at the beginning, but I'm sure there's lots of us who don't check on a regular basis to see that that policy continues to be in effect. All right, Wayne, let's pop this up another question. Cole says, is refusal to allow access reasonable grounds to charge back something as the condo?
Cole.
So reasonable access, reasonable grounds to charge back something. Well, if the condo corp wants access, they want access for a different reason. I mean, And then if they've said they need access or something and you refuse, I mean, you're certainly going to get, and you want to fight about it, there's going to be a legal bill.
There's the potential exists if the chargeback is based solely on the refusal to allow access, and you have to go to court to obtain an order to allow access, for example, then the court awards you costs, and your bylaws say that those costs can be charged back to the unit, and the court agrees that that's an appropriate case in which to do that, then potentially, yeah, that's reasonable grounds for a chargeback. But generally, it's a chargeback is justified so long as the expense that the corporation incurred and is seeking to charge back was the cause of, or was caused by the owner's act or omission or conduct or breach of the bylaws or something to that effect. You need to kind of consult each corporation's bylaws to see what the wording is exactly in order to see, does it apply in these circumstances. There's
lots, I mean, every condo corp has a different set of bylaws. So that's a really relevant comment to make, I think. All right. What else do we got, Wayne? Must be another question or two. Belden, speaking of that, since you brought it up, what are squatters? What rights do squatters have? How quickly can I get rid of squatters if possible? All right, Belden.
Well, I did just have a set of squatters actually, but we had an existing RTDRS order. So in that case, it was trespassing, and the police were called, and the police removed the squatters. It was as simple as that. I'm not aware that squatters have much, if any, rights in a condominium context in particular, or in any other context. So I wouldn't want to speak one way or the other about that. But in the condominium context, at least in my experience, it's never been an issue where there's you can prove that there's a trespass. You can call the police and have them removed.
Okay, that's a good one. We must have another question or two here. All that stuff we talked about. Oh my goodness. Okay, Erin, don't answer this one. Don't even start on this one. Don't even start. Airbnb, folks, you are looking at the queen of Airbnb law right here. Erin has been off to court and come up with a precedent-setting decision where she was the winner. Well, her condo corp was the winner because it's the client who wins. Erin just led the charge. So that is a big question, which regrettably, we're already past our time limit. So I think we're going to have to put this one aside, Erin. I mean, there's a number of other topics that we can have you come back. Obviously, we haven't exhausted everything there is, but let's see if there's anything else here. Alona says, my condo board tried to get enough signatures to mandate a marijuana-free building, but they couldn't get enough signatures, maybe because it's full of tenants who like to smoke in the summer. Marijuana and cigarette smoke goes inside the unit from the balcony. Is there anything that could be done to address that? So no bylaw, no rule around I'm gathering marijuana and cigarette smoking.
Yeah.
What do you think, Erin?
You might be able to go at it from a nuisance standpoint, but I have to be careful and caution people here because the word nuisance appears in most condo bylaws. What it means in that context is legal nuisance, though, not just an annoyance like it bothers me, I don't like the smell. Nuisance is an unreasonable interference with your use and enjoyment or with your right to do with your property. So if you have severe asthma, for example, and your neighbor's cigarette smoking is wafting into your unit, whether it's the summer, winter, no matter how it's getting in there or where it's coming from, but if it's wafting into your unit and causing you health issues, then that is potentially grounds for you to say to the condo board, hey, you need to do something. This owner cannot continue to smoke because it is seriously impacting my health. I did actually just see a court case out of Ontario last week where the condo corporation did not formally have did not originally have no smoking bylaws, but then at some point they passed no smoking bylaws. And in those circumstances, what they usually do is grandfather existing smokers for as long as they own their units. But what happened in this case was the smoker, the cigarette smoke was causing such a nuisance, a legal nuisance, to this adjacent unit owner who had severe asthma and allergies to cigarette smoke, such that the court ruled that the grandfathering be set aside and the owner was no longer permitted to smoke in their unit.
Okay, which brings up, I was going to make this comment at the beginning, Erin, but there are folks from all across Canada listening to us. And so we're in Alberta and we're talking about Alberta law.
That was actually in Ontario. But
it was Ontario, but I'm guessing that as much as condominium laws are provincially regulated, so there are different rules in every province, I'm guessing that there are similarities between provinces, so that what one court says in one province is at least influential, but you do need to know what your local rules are, I think.
Absolutely. For example, in Ontario, they've got not just bylaws, but also a declaration that you have to look to and consider. And here we've just got the bylaws and then the condo plan and potentially any rules that the condo board has come up with that we need to look at. So, but it does vary by province. The legislation is provincial specific, so you need to be sure which legislation you're operating under and know what your rights and obligations are in that regard.
All right. Ilona, when buying a newly built condo, how can we ensure you're not going to have a special assessment due to a builder's poor workmanship? Boy, Ilona, if we could give you the answer to that, we could retire.
Yes.
Oh.
I mean, as much as I would, as I love the idea of new builds and, having everything brand new and nobody else having lived there before, they scare me for good reason. I've seen so many problems with new builds, especially in recent years, and especially in condos, whether it's a high-rise condo or a wood-framed condo, there seem to be issues. In my opinion, it's good to maybe wait a couple of years and not buy brand new. That's just me. That's my personal view. But what I see is that issues tend to develop within the first 5 to 7 years. They make themselves known during that time. So if you're going to have a developer lawsuit and special assessments for repairs or to fund legal fees, they're going to probably happen within that time period. There is an ultimate 10-year limitation period for most lawsuits, where whether you discovered it or not, if 10 years have elapsed since the cause of action arose, then you can't bring suit. It's subject to a couple of exceptions that I'm not going to get into here. But so that's why 7 to 10 years is probably a better time to start looking at a building. Once it's been around for 7 to 10 years, the chances of a developer issued or developer quality issues or construction issues arising are much less. You'll know them then.
It's a tough one. I see so many of it. I get so many questions around builder issues in new condos. So, well, we've already had a vote, Erin, to bring you back for, here's another vote to bring you back for another session. So I think we're going to stop now because we've got lots left to talk about. Airbnb will fill at least a half or 3/4 of an hour on another time. So this has been illuminating. I mean, I know lots about this, but I've picked up a few nuggets and I've really enjoyed your presentation. It's a good combination, I feel anyway, of the legal side and the practical side, which everybody wants to know. So I'll just talk for everybody and say thank you very much, Erin, for showing up tonight after a long, tough day at the office and helping us out. And we're definitely going to do this again. So thank you very much.
Well, thank you so much for having me. It was my pleasure. I had a lot of fun tonight, actually, and I'd love to come back.
Great. Well, on that note, it's time to sign off, folks. So I'll wave goodbye, and we will certainly see you next week live at 5. It won't be Erin next week live at 5, but we will definitely rebook her. And on that note, good night, everybody.